Okay, I'm going to read Dadurian versus the Underwriters at Lloyd's, London. This is from the U.S. Court of Appeals, the First District. Campbell gave the opinion of the court in 1986. This diversity case arose out of the refusal of defendant appellant Lloyd's, London, Lloyd's, to indemnify plaintiff appellee Paul Dadurian after he claimed the loss of certain jewelry that he allegedly owned and that he had insured under a Lloyd's insurance policy. Defenses to the suit for non-payment, Lloyd's asserted that Dadurian's claim was fraudulent and that Dadurian had knowingly made false statements about facts material to his claim. The jury entered special verdicts favorable to Dadurian, resulting in his recovering $267,000 plus interest. Lloyd's moved for the United States District Court for the District of Rhode Island denied the motion and Lloyd's appeals. As we find the jury's verdict was against the great weight of evidence, we vacate and remand for a new trial. So that's the conclusion and also the procedural context. 1. Dadurian claimed that he purchased 12 pieces of specialty jewelry for investment purposes over a period of 30 months from August 1977 to January 1980. The pieces allegedly ran in price from $12,000 to $35,000, costing him $233,000 in total. Dadurian testified that he purchased all the jewelry from James Howe, a jeweler in Providence, Rhode Island, and paid for each of them in cash. Dadurian did not present any sales slips, receipts, or other documents or transfer reflecting any of his alleged purchases. And Howe not only presented no records of his sale of the jewelry to Dadurian, but he could not remember from whom he had originally obtained the jewelry and had no records showing that the jewelry had ever actually been in his possession. On or about March 2, 1980, Dadurian purchased a jewelry floater policy from Lloyd's, which insured him against loss of items of jewelry. The jewelry pieces were described on an attached schedule, which also set forth the maximum amount recoverable for each piece. The maximum recoverable under the policy was $267,000. Dadurian obtained insurance coverage on the strength of 8 appraisal certificates for the jewelry, which he prepared by Howe at Dadurian's request. Some certificates were dated on the same day as certain of the alleged purchases, while the others were dated months later. Dadurian claimed that on or about April 12, 1980, robbers entered his home and forced him to open his safe where the jewelry was kept. He was shot in the right shoulder, allegedly by one of the robbers, and was taken to the hospital. It is Dadurian's contention that the insured pieces of jewelry were stolen during the robbery. After preliminary investigation by an adjuster representing Lloyd's, Dadurian was asked to appear for under oath 1980 and again on May 28, 1981. Because the alleged false and fraudulent statements made under oath by Dadurian at his examination, Lloyd's refused to indemnify Dadurian for the claimed losses. On March 31st, 1982, Dadurian brought this action in the district court seeking compensation for his losses under the jewelry insurance policy issued by Lloyd's. The action was tried before a jury from October 29th through November 5th of 1984. The jury rendered 4 special verdicts, all favorable to Dadurian, that Dadurian had been armed on April 12, 1980, that he had not given false answers or information on the material subject, that he was examined under oath before the commencement of the suit, that he had not made any false statement or fraudulent claims as to any of the 12 jewelry items for which he claimed a loss, and that the total fair market value of all the jewelry on April 12, 1980 was $260,000. Judgment was entered for plaintiff in the amount of $267,000 with interest. Pursuant to Federal Rule of Civil Procedure 50, Lloyd's moved for judgment NOV, or in the alternative for a new trial. The district court denied defendant's motion, and this appeal followed. A little bit of procedural context there to turn the page. Part 2, Lloyd argues on appeal that Dadurian swore falsely and necessarily knowingly with respect to at least 2 key issues. In that either instance, the false swearing was sufficient to void the insurance policy. First, Dadurian is said to have clearly lied in asserting that he purchased and owned the 12 pieces of jewelry for which he later obtained the insurance. And second, he is said to have knowingly lied in telling Lloyd's at the formal examination under oath conducted before this action was begun that the cash he used to purchase the jewelry came from certain bank loans. Lloyd's contends that evidence presented at trial was so overwhelmingly against Dadurian on both these issues that no reasonable jury could have rendered a verdict in his favor. Part A, the purchase of the jewelry. Pointing to the suspicious absence of documentation for any of the jewelry purchases, Lloyd asserts that the record shows that Dadurian had sworn falsely when he testified to having purchased the jewelry at all. Dadurian procured the Lloyd's insurance on the basis of written appraisals executed by records of the alleged sales to Dadurian. Moreover, although Dadurian testified to specific dates and prices paid for each of his jewelry purchases in support of his story of ownership, his testimony that he had obtained that but whatever may be thought of Dadurian's story, we cannot say as a matter of law that no jury could have properly found that Dadurian had purchased the jewelry as he claimed. Nor can we say the verdict on the issue was so far contrary to the clear weight of the evidence as by itself to provide grounds for our ordering the district court to grant a new trial. By its not only did Howe testify at trial that he sold each one of the jewelry pieces to Dadurian at the prices Dadurian claimed, but Howe's employees Cheryl Costino and Edward Pro, this doesn't sound like French people, gave testimony which in material respects tended to support the story that Dadurian purchased at least some jewelry items from Howe with cash. And Howe and Costino testified that they did not usually give receipts for cash purchases of investment jewelry or of jewelry sold on consignment, thus tending to explain why Dadurian had no receipts. Despite extensive cross-examination by counsel for Lloyd's, the jury apparently chose the testimony of Dadurian and his witnesses, and the jury was entitled to overlook the lack of documentation for the purchases. Part B in Section 2 is the source of funds that certain specific bank loans. It is so because under the Lloyd's policy, Dadurian was required to give such information and evidence as to the property loss and the circumstances of the loss as the underwriters may reasonably require and as may be in the assured's power. And it is undisputed that under the policy as well as under established case law, knowingly false testimony by Dadurian as to any fact considered material to his claim voids the policy. The district court instructed the jury, and Dadurian does not dispute that the issue of where he obtained the cash used for his jewelry purchases was material to the claim. To be considered material, the statement need not relate to a matter or subject which ultimately proves to be decisive or significant in the ultimate disposition of the claim. Rather, it is sufficient if the statement was reasonably relevant to the insurance company's investigation of the claim. We agree that where Dadurian got the cash was material to his insurance claim, since Dadurian insisted that he paid Howe a total of $233,000 in cash over a 30-month period for the jewelry, and the credibility of his story, and hence of Dadurian's ownership of the insured items, turns in part on his ability to explain plausibly where he obtained such large sums of cash. The details of Dadurian's testimony about the bank loans are as follows. Soon after the alleged robbery of the jewelry items in April 1980, Dadurian was interviewed by an adjuster for Lloyd. At this initial interview, Dadurian explained the sources of his cash, stated that he may have borrowed from the bank for the purchase of certain of the personal items. He would be required to appear at a formal examination under oath for further questioning, at which time he should be prepared to produce all documents in any way relating to the occurrence of the loss. At the first examination session on September 10th of 1980, and again at the second session on May 28th, 1981, when he was examined under oath by counsel for Lloyd, Dadurian testified to the effect that most of his cash had come from loans. From the Rhode Island Hospital Trust National Bank Hospital Trust. During the two sessions, Dadurian was specifically questioned in turn about the sources of the cash used to purchase each one of the jewelry pieces. For 11 of the 12 items, Dadurian identified the individual promissory notes of his by date and by loan amount that purportedly represented the bank loans as the source of $166,000 of the $233,000 which he claimed to have paid to Howe. At trial, however, Richard Needsy, an employee of the bank, testified that the loans associated with 4 of the jewelry pieces, totaling $49,500, were simply renewals of earlier loans which could not have generated any cash for Dadurian. He also proceeded simply renewals. One second. He also produced bank statements for Dadurian at Hospital Trust showing that the proceeds from several other loans, which Dadurian had identified as having financed a number of the jewelry pieces, had been deposited in those accounts and then withdrawn in too small amounts over a period of time to have even been used for purchasing the jewelry, as Dadurian claimed. Needsy further testified that proceeds on yet another loan supposedly associated with the jewelry item had been deposited in a corporate account of the company named U.S. Enterprises, Inc., and that Dadurian had stated the purpose of the loan was real estate investment. Confronted with this cumulative evidence, Dadurian essentially conceded that some, if not most, of the promissory notes he had selected had been the wrong ones, and that his testimony as to the sources of the funds were therefore in part false. He insisted, however, that he had selected the notes to the best of his recollection and that he had been honestly mistaken. Since it is thus uncontroverted that a substantial number of Dadurian's representations under oath about the sources of his cash were untrue, the only remaining question is whether Dadurian made these false statements knowingly or whether he was simply mistaken in good faith as he claims. So this is issue 3. False swearing is swearing knowingly and intentionally false and not through mere mistake. From Black's Law Dictionary, 725, revision 5th edition, 1879. Lloyd forcefully contends that where Dadurian testified with such uncertainty yet incorrectly about so many of his promissory notes and bank loans, the inference of intentional falsehood is so compelling as to render the jury's finding contrary, at very least, to the great weight of the evidence. After carefully considering the entire record, we find that the great weight of evidence indicates overwhelmingly that Dadurian knew he was giving false testimony. At the formal examination under oath, Dadurian specifically identified 13 promissory notes, apparently from those he had given Lloyd sometime before the examination, and explicitly linked each note to a particular jewelry purchase. He did not qualify his identifications, but rather couched his testimony in terms of misleading certainty. Only when confronted at trial with the patent falsity of his earlier testimony did Dadurian testify by way of explanation that he had made his selections only to the best of his recollection in order to satisfy the insurance company's inquiries. It was only then that he explained that because he had files and files of such promissory notes in his possession, He must have simply selected the wrong ones under pressure of time and circumstances. So this explanation strains credulity. This was not a case where Dadurian was time at the examination with files and files. It was promissory notes and asked to come up with correct ones on the spot. Rather, it was Dadurian himself who originated and put forth the story that most of his cash had come from bank loans, and it was Dadurian who apparently first tendered the supposedly relevant promissory notes to Lloyd's at some time before the formal examination. Dadurian admitted that he had known before the first examination sessions that he would be questioned further about the bank loans. He apparently marked each of the notes before the examination sessions with the number of the jewelry piece that with which it was supposedly associated. By the first session in September of 1980, and certainly by the May 1981 session, Dadurian had had ample notice as well as opportunity to discover the correct promissory notes. If he found he was wrong or in doubt, to say so. And the contested facts simply belie Dadurian's excuse that he was pressured into making identifications premature. Dadurian had much to gain by providing a plausible explanation for the sources of his cash. By piecing together notes executed on dates close to the times of the alleged purchases, he could hope to create an impression of credibility, that he linked the notes to the jewelry purchases so positively without bothering to ascertain readily available information showing that they were not so related indicates at the least a willful misrepresentation as to the state of his own knowledge concerning the matters to which he was testifying. So back to the definition of false swearing. We think the only fair inference from this kind of total indifference to the truth or falsity of his assertions was that Dadurian he was not telling the truth. It follows we believe that the jury's verdict was against the clear weight of the evidence insofar as it found that Dadurian did not knowingly give false answers or information on any material subject when he was examined under oath before commencement of the suit. We emphasize that Dadurian himself conceded that some of his answers were incorrect, and it is clear the district court properly found them material. This leaves open only the question of their possible innocence, which, to be sure, Dadurian attested to, but with implausible explanations as to why he put forward these patently unfounded and incorrect assertions. We conclude that the jury's finding that Dadurian did not give knowingly false answers was contrary to, say, the weight of the evidence, contrary to the great weight of the evidence. For the respect that the verdict to stand would, in our view, amount to a manifest miscarriage of justice, we hold, therefore, that the court abused its discretion in denying defendant's motion for a new trial and remand the case for retrial by a new jury. We are mindful of the alternative plea by Lloyd that we should reverse the court's refusal to grant a judgment NOV and, in effect, direct a finding for Lloyd's rather than order a new trial. Whether to do so is a very close question. A factor weighing against the alternative is that Lloyd's had the burden of proving that Dadurian was lying, and this circuit, like most courts, is reluctant to direct a verdict for a party having the burden of proof. The issue, moreover, involves the determination of credibility. Hence, even though we find it hard to see the reasonable jury could reach any result other than that Dadurian was knowingly lying, we believe that the more appropriate relief is a new trial. A remaining question is whether a new trial should encompass both the issue of Dadurian's ownership of the jewelry and the issue of his own knowingly false testimony as to the sources of his funds. We hold that it should, even though it was on the latter issue that the district court erred. Dadurian's credibility is cast into serious doubt by our finding that the clear weight of the evidence shows that he must have knowingly lied about a material issue. It follows that the loss of credibility necessarily affects the jury's finding in Dadurian's favor on the issue of this. Since Dadurian was his own main witness for all aspects of his story, a new trial as to both issues also makes sense, since the issue of where Dadurian obtained the cash to make his purchases is so interrelated with the question of whether Dadurian bought the jewelry he claimed, as to make it difficult to hold a meaningful trial on the first without the second. Vacated and remanded for trial. Wait 2 minutes to read that movie.